Now, there are two objections to what I've said that if you want to talk about them in the discussion, we can. One is the so-called ticking bomb hypothetical, and I think the answer there is it's not going to change the legal or the ethical analysis. And the other is, doesn't utilitarianism, which doesn't start with personhood, but starts with personal preferences, doesn't that provide an ethical basis for permitting torture? And my answer to that would be, no, that's a misunderstanding of utilitarianism. So that's the end. I do want to say I would love to see us develop a kind of a template core law school course on law and torture, and it's something that we could do as a practical matter.
And maybe something you could teach to the Office of Legal Counsel, too. Okay, thank you, Bob. We'll begin with some... a very ethical or eloquent restatement of ethical principles. What comes to my mind is that to avoid harm to the client, one of the things that you've taught me is that you need to calm the client down. And in the case of the OLC, it does seem like the OLC was not calmed down, but rather stirred up. And in that case, the ultimate client, in the case of this constitutional issue, was the American public.
It's I certainly agree with that last. I agree with you entirely about calming the client down. And you know, you have relations with clients. You have to figure out how to deal with them best. But here we are at the top of the government at issues that are as crucial as you can think of. And in those situations, a lawyer can't panic. The lawyer has got to be detached from himself. You know, we're taught you to detach from the client. You've got to detach even from yourself. You can't panic. And you've got to step back and calm yourself and then calm the client. I quite agree. Now, the problem of who your client is a complicated problem, and I can't do a lot with it, but in the time we have. But generally, when you represent an organization, it's a question: do you represent the CEO of Enron, or do you represent the shareholders, or do you represent the sort of the corporation in some abstract way? And that's the same thing with the United States. Are you really giving advice to the president? Are you giving advice to the presidency? Are you giving advice to the country? And so you have, it's a problem in a technical sense how to define your client. And I don't think that the lawyer can say, well, my advice is really for the American people as my client. I think that you have to, whether you like it or not, the president got more votes than you did, and is more accountable to them. But I do think that you can both say that part of my advice is not just to the incumbent. And after the Enron scandals, they changed the rules on corporate counsel. So they have obligations to go over the head of the executives that they advise. And I think with the presidency, it's hard to find anyone to go over the president's head. But what you can do is insist on giving advice that does have this quality of attempting to state law that will govern for a longer period of time the whole institution of the presidency over a longer period of time. In other words, you do have to try to detach from just pleasing the client. But I don't think you can say it's the American people that are the client.
Comments?